I knew something was wrong the moment I saw Margaret Whitmore standing in my driveway with a measuring tape, a legal pad, and that expression she always wore when she was about to make someone's life miserable. It was a Saturday morning in June 2025, and I had just returned from grabbing coffee at the local Starbucks in Scottsdale, Arizona, where I'd lived for the past 8 years. My name is Kevin York, and I'd dealt with Margaret's antics as HOA president for years, but this felt different. "Can I help you, Margaret?" I called out, stepping out of my truck with my iced coffee in hand. She didn't even look up from whatever she was writing. "Just documenting what's legally mine now, Kevin. Don't mind me." I walked closer, feeling my stomach drop as I realized she was measuring my storage shed. The one I'd built 6 years ago with proper permits from the city. The one that sat 15 feet from my property line, well within my own backyard. "What are you talking about?" "This shed." She tapped it with her pen like it was a gavel. "According to Arizona law, I've been maintaining the area around this structure for over 5 years. That constitutes adverse possession. This shed now belongs to me, and by extension, it needs to be removed because it violates HOA aesthetic guidelines." I actually laughed. I couldn't help it. "Margaret, that shed is on my property. You can't just claim adverse possession of something that's entirely within my fence line." "Actually, Kevin, I can. I've consulted with my attorney, and he assures me that my case is solid. I've been trimming the bushes around this shed. I've reported it to the HOA multiple times for violations, and I've taken an active interest in this portion of your yard for years. The law is clear." "The law is clear that you're insane," I said, immediately regretting letting her get under my skin. "Margaret, you don't maintain anything in my yard. I have a landscaping service that comes every 2 weeks. You've never touched my property." She pulled out her phone and started scrolling through photos. "I have documentation of every time I've picked up debris that blew from your shed onto the common area. I have emails to the HOA board about this eyesore. I have witnesses who will testify that I've expressed ownership interest in rectifying this violation." Expressing interest isn't the same as adverse possession. You need to actually possess the property openly, notoriously, continuously, and hostilely for 10 years in Arizona. Not just complain about it. Her smile was venomous. "We'll see what a judge says. I've already filed the paperwork. You'll be served next week." "And Kevin?" "I'd start looking into storage solutions because when I win, that shed is coming down immediately." She walked away before I could respond, leaving me standing in my own driveway, wondering if I'd just hallucinated the entire conversation. I went inside and immediately called my buddy Derek, who worked as a paralegal at a law firm downtown. "She did what?" Derek said when I explained the situation. "Filed for adverse possession of my storage shed." "Derek, this is completely insane, right? I'm not missing something?" "No, you're not missing anything. Adverse possession requires actual possession. You can't adversely possess something that's inside someone else's fenced property while they're actively using and maintaining it. This is going to get thrown out immediately." That's what I thought. But she seemed so confident. She said she has an attorney. Then her attorney is either incompetent or she's lying about what he told her. "Look, you'll need to respond to the filing. Do you have a lawyer?" "I've used Thomas Richardson for real estate stuff before." "Call him Monday morning." "This is ridiculous, but you still need to respond properly. Don't ignore it just because it's baseless." I spent the rest of the weekend fuming. Margaret had been a thorn in my side since I'd moved into this neighborhood in 2017. The Saguaro Hills community was a nice planned development with about 200 homes, a community pool, and some decent walking trails. Most of the neighbors were reasonable people. Then there was Margaret. She'd been elected HOA president in 2019, running unopposed because nobody else wanted the job. Since then, she'd turned into a petty tyrant. She'd fined people for leaving their trash cans out 15 minutes too long. She'd tried to ban certain flowers because they weren't desert appropriate. She'd attempted to institute a rule requiring all vehicles to be white, beige, or gray to maintain neighborhood aesthetics. Most of her ridiculous proposals got voted down by the board, but she made everyone's lives difficult in small ways. She'd walk the neighborhood with a tablet, photographing anything she deemed a violation. She'd send certified letters demanding compliance with rules she'd invented. She'd call emergency board meetings to discuss someone's wind chimes. But this was a new level of crazy. Even for her, the legal papers arrived the following Thursday via certified mail. I sat at my kitchen table reading through the complaint, becoming more incredulous with each paragraph. Margaret claimed that she'd exercised dominion and control over my shed since 2019. She listed various acts that supposedly demonstrated her possession, including reporting it to the HOA for violations, photographing it extensively, researching its construction permits, and maintaining the surrounding area. None of that was actual possession. I'd built the shed in 2019 with proper city permits. It was a nice 12 by 16 structure where I stored my tools, lawn equipment, and outdoor recreational gear. It was painted to match my house, had a proper foundation, and was completely unremarkable. The only reason Margaret hated it was because she'd voted against approving it at the HOA architectural review meeting. And she'd been outvoted 3-1. I called Thomas Richardson that afternoon. He was a solidly built guy in his 50s who'd handled my home purchase and had dealt with some HOA nonsense for me in the past. "Kevin, this is the most ridiculous filing I've seen in 20 years of practice," he said after reviewing the documents I'd emailed. "She doesn't have a case. This won't survive a motion to dismiss, so what do? We file a response denying her claims, and we file a motion to dismiss for failure to state a claim. The judge will see immediately that she hasn't alleged facts sufficient to support adverse possession. I'd be shocked if this takes more than one hearing. Should I be worried about costs? I don't want to spend thousands fighting something this stupid. I'll be honest with you, this should be quick. I'll file the motion to dismiss, we'll have a hearing, and the judge will toss it. You're looking at maybe 3 to 5 hours of my time total. Call it $2,000 unless something unexpected happens." It wasn't cheap, but it was better than letting Margaret steal my shed through some legal loophole I didn't understand. "Let's do it." Thomas filed our response and motion to dismiss within a week. In the meantime, Margaret ramped up her campaign. She started posting in the neighborhood Facebook group about property rights and HOA violations. She didn't mention me by name, but everyone knew what she was talking about. "Some homeowners think the rules don't apply to them," she wrote. "They build structures without proper HOA approval and then act surprised when there are consequences. The HOA exists to protect all of our property values, and I won't apologize for enforcing our covenants." I wanted to respond, to point out that I'd gotten full HOA approval and that she was currently trying to steal my property through a frivolous lawsuit, but Thomas advised against it. "Don't engage," he said. "Anything you say could potentially be used against you. Let her rant. Anyone with half a brain can see through it." Several neighbors reached out privately to offer support. My next-door neighbor, Jim Patterson, even offered to testify if needed. "Margaret's lost her mind," he told me over the fence one evening. "I've lived here since this development was built in 2009. I've seen her evolution from normal person to whatever this is. The power went to her head. Did she used to be reasonable? She was fine until she became HOA president. I think she just needed something to control. Her kids are grown, her husband works long hours, and she fixated on the HOA as her purpose. It's sad, really, but that doesn't excuse this nonsense." The hearing was scheduled for July 15th at the Maricopa County Superior Court. As the date approached, Margaret's behavior became more erratic. She started leaving notices on my door demanding I cease trespassing on her shed. She took photos of me going in and out of my own storage building and posted vague threats on social media about prosecuting theft. "She's digging her own grave," Thomas said. "If she keeps this up, we might have grounds for a harassment claim." The morning of the hearing, I put on a suit and met Thomas at the courthouse at 8:30. The hearing was scheduled for 9. Margaret arrived at 8:45 wearing a pantsuit and carrying a briefcase that looked like she'd bought it specifically for this occasion. Her attorney, a tired-looking man in his 60s named Robert Chen, appeared less confident than she did. We waited in the hallway outside the courtroom. Margaret kept shooting me looks that I assumed were meant to be intimidating. Mostly she just looked unhinged. "All rise for the Honorable Judge Patricia Morrison," the bailiff announced as we filed into the courtroom at 9 sharp. Judge Morrison was a no-nonsense woman in her early 50s with sharp eyes and an expression that suggested she'd already read the filings and wasn't impressed. We took our seats and she glanced at the case file. "This is a motion to dismiss regarding an adverse possession claim. Is that correct?" "Yes, Your Honor," Thomas said, standing. "I've reviewed the complaint and the motion to dismiss, Mr. Chen. I'll give you an opportunity to explain how your client has established the elements of adverse possession, given that the property in question appears to be located entirely within the defendant's fenced yard and has been continuously used and maintained by the defendant." Robert Chen stood slowly. "Your Honor, my client has exercised control over the disputed property through her oversight as HOA president. She's reported violations, documented the structure, and maintained awareness of its existence for over 5 years. That's not possession, Mr. Chen. Surely you understand the difference between being aware that something exists and actually possessing it." "Your Honor, in her role as HOA president, my client has a duty to monitor all properties within the community. This monitoring constitutes a form of constructive possession." I watched Judge Morrison's expression shift from skeptical to annoyed. Constructive possession in the context of adverse possession requires actual control and use of the property. Monitoring something as part of an HOA role is not control. "Mr. Chen, has your client ever actually used this shed, stored items in it, maintained it, excluded the property owner from it?" "She's documented it extensively, Your Honor." Taking photographs of someone else's property doesn't create a possessory interest. Does your client have any evidence of actual physical possession and use? Robert Chen shuffled his papers. She's trimmed vegetation near the structure. On her client's property or on common areas. The vegetation was near the property line. So on common areas or on the defendant's property? Common areas, Your Honor, but in close proximity to the shed. Judge Morrison removed her glasses and rubbed the bridge of her nose. Mr. Chen, I'm going to ask you directly. Did you advise your client that she had a viable adverse possession claim, or did she file this against your advice? There was a long pause. My client was insistent that she had grounds, Your Honor. I advised her of the elements required, but she believed her documentation would be sufficient. Your client's belief doesn't change the law, Miss Whitmore. Judge Morrison looked directly at Margaret. Do you understand that adverse possession requires you to have actually possessed and used the property as if it were your own, openly and continuously, for 10 years? Margaret stood up, which prompted the judge to say, "You don't have to stand, but you may answer." Margaret remained standing anyway. Your Honor, I've been protecting this community from violations for years. That shed is an eyesore that violates our architectural standards. I've done everything in my power to document and remedy the situation. That's not what I asked. Have you ever stored anything in that shed? Used it for any purpose? Prevented Mr. York from accessing it? No, but I've exercised my authority as HOA president to monitor it. Monitoring isn't possession. Mr. York has the shed on his property, maintains it, uses it, and has never been excluded from it. You haven't established even the basic elements of an adverse possession claim. This is a misuse of the court's time and resources. Judge Morrison looked at the papers in front of her and then back at Margaret. Mrs. Whitmore, if you had issues with the shed under HOA rules, there are proper procedures for that. Filing a fraudulent adverse possession claim is not one of them. It's not fraudulent, Margaret protested. My attorney said your attorney has acknowledged that you filed this despite knowing you didn't meet the legal requirements. That's concerning. Mr. Richardson, I'm granting your motion to dismiss with prejudice. Ms. Whitmore, you are barred from refiling this claim. Additionally, I'm awarding attorney's fees to the defendant. You will reimburse Mr. York for the cost of defending against this frivolous action. I felt a wave of relief wash over me. Thomas had been right. It took less than 10 minutes for the judge to see through Margaret's nonsense. Furthermore, Judge Morrison continued, I'm issuing a warning. If you file any further frivolous claims regarding this property or harass Mr. York about this matter, you could face sanctions including fines and potential contempt charges. Do you understand? Margaret's face had gone red. This is a miscarriage of justice. That shed violates. That's enough. Judge Morrison cut her off. If you have HOA concerns, address them through proper HOA channels, not through fraudulent legal claims. We're done here. Bailiff, please provide Mr. Richardson with the necessary paperwork for the fee award. We were dismissed. I walked out of the courtroom feeling like I'd just witnessed something surreal. 10 minutes. The judge had dismantled Margaret's entire case in 10 minutes and ordered her to pay my legal fees. In the hallway, Margaret was arguing with Robert Chen in a harsh whisper. I caught fragments as I walked past with Thomas. You told me we had a case, I told you the elements required, and you insisted. This isn't over. Thomas pulled me aside once we were away from them. That went exactly as expected. Better, actually. The fee award means you'll get your legal costs back. I'll send her the invoice, and she'll have 30 days to pay. What if she doesn't? Then we can pursue collection, but most people pay court-ordered fees. She won't want more legal trouble. Do you think she'll actually stop? Thomas sighed. Honestly, people like her don't usually stop until they're forced to. But the judge was clear. If she harasses you further, document everything. We can go back to court for a restraining order if necessary. I thanked Thomas and headed home, expecting to feel triumphant. Instead, I just felt exhausted. Dealing with Margaret's delusions had taken up weeks of my life and caused stress I didn't need. Even with the fee award, it was time I'd never get back. When I got home, I noticed Margaret's car was already in her driveway. She lived 4 houses down, close enough that I saw her more often than I wanted to. I went inside and tried to forget about the entire situation. That lasted about 3 hours. At 2 in the afternoon, someone rang my doorbell. I opened it to find a woman in her 30s with a badge identifying her as working for the City of Scottsdale Planning and Development Department. Mr. York, I'm Amanda Stevens from Planning and Development. We received a complaint about an unpermitted structure on your property. I need to do an inspection. The shed? I have the permits. This is harassment from my HOA president. I just came from court where a judge dismissed her frivolous lawsuit about it. Amanda looked sympathetic but professional. I still need to verify the permits and do a basic inspection. It's procedure once a complaint is filed. I showed her to the backyard, fuming. Margaret had clearly called the city immediately after losing in court. Amanda measured the shed, checked the setbacks, and reviewed the permit documentation I pulled up on the city's website on my phone. Everything looks fine, she said after 20 minutes. The shed is properly permitted, meets all setback requirements, and appears to be constructed according to the approved plans. I'll file a report that the complaint was unfounded. Will the person who filed the complaint face any consequences for wasting your time? Unfortunately, no. We have to investigate all complaints. However, if someone files multiple unfounded complaints, we do flag it as potential harassment. Has this person filed other complaints about your property? Not with the city as far as I know, but she's filed dozens of HOA complaints over the years about various made-up violations. I can only speak to city matters, but if she files another unfounded complaint, it'll be noted in our system. I'm sorry you're dealing with this. After Amanda left, I called Thomas and told him what happened. Document it, he said. Keep a log of every time she contacts you, files a complaint, or takes any action related to the shed or your property. If we need to seek a restraining order, we'll want a clear pattern of harassment. I started a spreadsheet that afternoon, logging everything I could remember from the past several weeks, including dates, times, and descriptions of Margaret's actions. It was longer than I'd realized. The next incident came 2 days later. I received a notice from the HOA that I was being fined $500 for unauthorized structural modifications to my property. The notice cited the shed and claimed I'd never received proper architectural approval. I dug out my files from 2019 and found the architectural review approval letter, signed by 3 board members including Margaret herself, who'd voted against it but been outvoted. I scanned it and emailed it to the HOA board with a strongly worded message pointing out that the fine was retaliatory and that I'd be happy to discuss the matter with my attorney if it wasn't rescinded immediately. The board president, a reasonable guy named Frank Delgado, called me within an hour. "Kevin, I'm so sorry. Margaret submitted this fine without board approval. She doesn't have unilateral authority to issue fines. I'm rescinding it immediately and sending a formal apology. This is getting out of hand, Frank. She just lost a lawsuit over this shed. The judge ordered her to pay my attorney fees and warned her about harassment. Now she's filing false complaints with the city and trying to fine me through the HOA. This has to stop." I agree. The board is actually meeting tomorrow night. Several of us have been discussing the situation. Would you be willing to attend and explain what's been happening? Absolutely. The HOA board meeting was held at the community center on a Wednesday evening. About 30 homeowners showed up, which was high attendance for a regular meeting. Word had spread about Margaret's lawsuit and the judge's dismissal. The meeting started with standard business, approving minutes and discussing upcoming community events. Then Frank moved to new business. "We need to address a serious matter involving HOA leadership and potential abuse of authority. As many of you know, there's been a dispute between our HOA president and a homeowner regarding a properly permitted storage shed. I'm going to ask Kevin York to explain the situation, and then the board will discuss appropriate action." Margaret's face went pale. "This is highly irregular. You can't just, you're out of order, Margaret," Frank said firmly. "Kevin has the floor." I stood and gave a brief summary of events, starting with Margaret measuring my shed, her adverse possession claim, the court hearing, the judge's dismissal and fee award, and the subsequent harassment, including the city complaint and the unauthorized fine. I kept it factual and unemotional. When I finished, there was silence in the room. Then hands started going up. "I have a question," said a woman I recognized from the neighborhood Facebook group. "Why did Margaret think she could claim someone else's property?" "You'd have to ask her," I said. But the judge was very clear that her claim had no legal basis. Another homeowner stood. "I've been fined twice this year for violations that weren't actually violations. Margaret sent me a notice about my mailbox being the wrong color, but it's the same mailbox that's been there since the house was built in 2011. When I pointed that out, she dropped it, but she never apologized." More people began sharing stories. Margaret had apparently been on a violation spree for months, targeting people with petty or imagined infractions. The board members looked increasingly uncomfortable. Frank finally held up his hand for quiet. "Thank you all for sharing. It's clear we have a pattern of concerning behavior. The board needs to discuss this and determine appropriate action. We'll take a 15-minute recess." The board members, minus Margaret, went into a side room. Margaret sat rigidly in her chair, staring straight ahead. Nobody approached her. The tension in the room was thick. When the board returned, Frank looked grim. "The board has voted to remove Margaret Whitmore as HOA president, effective immediately, based on abuse of authority, harassment of homeowners, and actions that have exposed the HOA to potential legal liability. Additionally, we're suspending her from the board pending a vote by the full community at a special meeting to be scheduled within 30 days. "You can't do this," Margaret said, her voice shaking. "I've dedicated years to this community. I've protected property values and enforced standards that the rest of you are too weak to uphold. You've harassed residents and filed a fraudulent lawsuit, Frank said. The judge literally called your claim frivolous and ordered you to pay damages. You filed a false complaint with the city. You attempted to issue an unauthorized fine in retaliation. Margaret, you've crossed every line. This is a witch hunt. Kevin has turned you all against me because he doesn't want to follow the rules. Kevin's shed was properly permitted and approved by this board in 2019, Frank said. You voted against it, but you were outvoted. That doesn't give you the right to wage a personal vendetta. The decision stands. You're removed as president. I'll be taking over until we can hold elections. Margaret stood abruptly, grabbed her belongings, and stormed out. The room remained silent for a moment after the door slammed behind her. The special meeting to remove Margaret from the board entirely was held 3 weeks later. It required a vote of the community members, and the turnout was the highest anyone could remember. Margaret didn't attend. The vote was 147 in favor of removal, 12 against with 3 abstentions. In the meantime, Margaret made one more ill-advised move. She refused to pay the court-ordered attorney fees. Thomas sent her the invoice, certified mail, and she sent back a letter claiming the fees were excessive and unjustified, and that she was exploring her appellate options. She's not going to win an appeal, Thomas told me, and she's just making this worse for herself. We'll file for enforcement of the judgment. We went back to court in mid-August. This time it was a different judge, Judge Robert Martinez, handling the enforcement hearing. Margaret showed up without an attorney. Whitmore, you were ordered by Judge Morrison to pay Mr. York's attorney fees in the amount of $2,150. Why haven't you paid? The fees are excessive, Your Honor. I believe the case was handled improperly, and I'm planning to appeal. You're outside your window to file an appeal. The judgment is final. Do you have the ability to pay this amount? I have the ability, but I dispute the amount. Your dispute isn't relevant. The court ordered you to pay. You have 2 options. Pay the full amount within 10 days, or we can set up a payment plan. Which would you prefer? Margaret's jaw clenched. I'll pay the full amount. Good. If payment isn't received within 10 days, Mr. Richardson can proceed with collection actions including wage garnishment and bank levies. Do you understand? Yes, Your Honor. I received a check from Margaret 8 days later. No note, just a check for the exact amount. I deposited it and hoped that would be the end of everything. For about 3 weeks it was quiet. Margaret stopped posting on the neighborhood Facebook group. She stopped walking around with her tablet photographing violations. She stayed in her house mostly, and when I did see her, she looked through me like I didn't exist. Then in early September, my doorbell rang at 7 in the morning on a Saturday. I opened it to find 2 police officers. Kevin York? Yes? We received a report of trespassing and theft. Do you mind if we ask you some questions? My heart sank. What's this about? Do you know a Margaret Whitmore? Yes. She's a neighbor. Let me guess, she filed a complaint about my storage shed. The officers exchanged glances. The older one, whose nameplate read Officer Patterson, said, she reported that you've been repeatedly trespassing on her property and stealing items from a storage structure that belongs to her. Officers, that storage shed is on my property. Margaret filed a lawsuit trying to claim it through adverse possession. A judge dismissed her case and ordered her to pay my attorney fees. This is harassment. Do you have documentation of the court case? I pulled up the case file on my phone and showed them the dismissal order. Officer Patterson read it carefully. Ms. Whitmore told us you built this shed on her property without permission. The shed is 15 feet from my property line, well within my yard. I have the survey from when I bought the house, the building permits, the HOA approval, everything. Officers, she's been harassing me for months. I have documentation if you want to see it. The younger officer, Officer Kim, spoke up. Can you show us the shed and the property line? I led them to my backyard and showed them the survey markers, the fence line, and the shed. It was obviously on my property, not even close to the boundary. This is clearly on your property, Officer Patterson said. Do you want to file a false reporting complaint against Ms. Whitmore? I hesitated. Part of me wanted to, but I also just wanted it to be over. What would that involve? We'd document that she filed a false police report, and she could face charges. Given the pattern you've described, it might be warranted. Let me think about it. I have an attorney I've been working with. Can I discuss it with him and let you know? Sure, here's my card. Call within 48 hours if you want to pursue it. After the officers left, I immediately called Thomas, even though it was Saturday morning. File the complaint, he said without hesitation. Kevin, she's escalating. She lost in court. She got removed from the HOA board. She had to pay your fees, and now she's filing false police reports. This isn't going to stop until there are real consequences. I just don't want to seem vindictive. You're not being vindictive. You're protecting yourself from someone who's clearly obsessed with harassing you. What's she going to do next? File more complaints? Try to claim your house? At some point, you have to draw a line. He was right. I called Officer Patterson and told him I wanted to file a complaint for false reporting. The process took a few weeks. I had to give a formal statement, provide all my documentation, and wait while the police investigated. In late September, I got a call from the Scottsdale Police Department letting me know that Margaret had been charged with making a false report to law enforcement, a misdemeanor. Her court date was scheduled for October 20th. I didn't have to attend, but the prosecutor's office said I might be called as a witness. In the meantime, I finally got a restraining order. Thomas helped me file for an order of protection based on the pattern of harassment, and it was granted. Margaret was ordered to stay at least 100 yards away from me and to have no contact. The criminal case was straightforward. Margaret tried to represent herself and argued that she genuinely believed the shed was on her property, despite all evidence to the contrary. The prosecutor pointed out that she'd lost a civil case on the exact same issue and had been told by a judge that her claim was baseless. The court found her guilty and sentenced her to probation, community service, and ordered her to continue complying with the restraining order. After that, things finally quieted down. Margaret put her house on the market in November and moved out by January 2026. I heard through the neighborhood gossip that she'd moved to Sun City, a retirement community where presumably someone else could deal with her HOA obsessions. The new HOA president, Frank, was reasonable and focused on actual community improvement rather than nitpicking violations. The neighborhood Facebook group became friendly again instead of a battleground. My storage shed continued to sit peacefully in my backyard, storing my tools and equipment exactly as it had been designed to do. Looking back on the whole saga, the thing that struck me most was how someone could become so fixated on being right that they'd destroy their own life over it. Margaret had lost her position, her reputation in the community, thousands of dollars in legal fees, and ultimately her home, all because she couldn't accept that a properly permitted storage shed was allowed to exist. The shed that started everything still stands in my backyard, a monument to one woman's bizarre crusade and spectacular failure. I got a new ladder last spring and hung it on the shed's side wall. Sometimes when I'm out there grabbing tools for a project, I think about Margaret and wonder if she ever realized how crazy the whole thing was. I doubt it. People like that rarely do. My buddy Jim from next door came over one afternoon in March while I was organizing the shed. He leaned against the doorframe and shook his head. "You know, I still can't believe how far she took it. Adverse possession. Who even thinks of that?" "Someone who Googled how to steal my neighbor's property and thought she'd found a loophole," I said. The best part was watching that judge's face. I wasn't there, but Frank told me she looked like she wanted to throw the gavel at Margaret. Pretty much. It was the fastest I've ever seen a case get dismissed. 10 minutes, Jim. All that drama, all that stress, and it took a judge 10 minutes to see it was garbage. Are you going to do anything special with the shed? You know, commemorate its victory? I laughed. It's a shed, it stores stuff. That's special enough. But privately, I was grateful for how things had turned out. The shed was still there, Margaret was gone, and I'd learned a valuable lesson about standing up to bullies, even when they're coming at you with legal paperwork and the authority of an HOA. The incident also changed how our HOA operated. Frank led an initiative to rewrite the governing documents with clearer checks and balances on board authority. No single board member could issue fines without a majority vote. All architectural decisions required written documentation. Homeowners were given a clear appeals process for any violations. The changes were approved overwhelmingly at a community meeting in February. "We let one person have too much unchecked power," Frank told me after the vote. "That's how situations like yours happen. The new rules should prevent it." "Should," I said. "Nothing's perfect, but it's better than what we had." He was right about that. The neighborhood felt different now, lighter somehow. People weren't afraid to put out holiday decorations or paint their front doors or plant flowers without worrying that Margaret would materialize with her tablet and a violation notice. I even served on the HOA board for a term, which I never would have considered before. It turned out that being involved in the process was the best way to ensure it didn't go off the rails again. We focused on actual community needs like maintaining the pool, organizing neighborhood events, and keeping up with landscaping in common areas. Revolutionary concepts? Apparently the storage shed became something of a neighborhood legend. New residents would hear the story and want to see it, like it was a historical landmark. I played along good-naturedly, but mostly I was just glad the saga was over. In April 2026, I got a letter from an attorney representing Margaret. My stomach dropped when I saw the return address, but it turned out to be nothing sinister. She was trying to sell her house in Sun City and needed to resolve some remaining issues from her Scottsdale property. The letter asked if I would sign a quitclaim deed, formally disclaiming any interest she might have ever asserted in my shed. I called Thomas. Is this some kind of trick? No, it's probably a title issue. When she filed the adverse possession claim, it created a cloud on her title. The title company for her buyer probably caught it and wants it cleared up. Signing the quitclaim just confirms that she has no interest in your property, which is already established by the court order dismissing her case. So I should sign it? Yes, but I'll review it first. Send me a copy. I signed the quitclaim a week later after Thomas confirmed it was standard language. That was the last I heard from Margaret Whitmore. The document felt like a final admission of defeat on her part, a legal acknowledgement that she'd been wrong all along. My life returned to normal. I went to work, maintained my house, used my storage shed without drama. It was blissfully boring. One Saturday in May, almost exactly a year after Margaret had first appeared in my driveway with her measuring tape, I was cleaning out the shed when I found an old paint can from the original construction. The color had been custom mixed to match my house, a specific shade of desert tan that took the paint store 3 tries to get right. I remembered Margaret arguing at the HOA architectural review meeting that the shed should be white, like some arbitrary standard she'd invented. The board had sided with me, agreeing that matching the house made more sense. She'd been furious, insisting that we were setting a dangerous precedent by allowing colored outbuildings. That meeting should have been a warning sign. Margaret hadn't cared about the color, she'd cared about being in control and having her way. When she lost that vote, she'd nursed the grudge for years until it festered into her delusional adverse possession claim. I tossed the old paint can in the trash and finished organizing the shed. Everything had a place now. Tools hung on pegboards, sports equipment was stacked neatly in bins, and the lawnmower had its designated spot. It was satisfying in a way that only a well-organized space can be. The irony wasn't lost on me that Margaret had wanted the shed gone because it was supposedly an eyesore, when it was actually one of the neater structures in the neighborhood. But the whole thing had never really been about aesthetics or property values or HOA rules. It had been about power and control and one person's inability to accept that she couldn't dictate every aspect of other people's lives. Jim came over later that afternoon with a 6-pack of beer, and we sat in my backyard admiring the shed like it was a piece of art. To the most famous storage building in Scottsdale, Jim said, raising his bottle. To surviving HOA insanity, I countered. We clinked bottles and drank. The Arizona sun was setting, painting the sky in shades of orange and pink. My shed cast a long shadow across the grass, solid and permanent and utterly unremarkable except for the story it represented. You ever think about writing this down? Jim asked. People would get a kick out of it. Who'd believe it? Woman tries to steal neighbor's shed through adverse possession and gets destroyed in court in 10 minutes? It sounds made up. Truth is stranger than fiction, my friend. Maybe he was right. The whole experience had been surreal from start to finish. But it had also been real. With real stress and real consequences and real money spent defending against something that should never have made it to court in the first place. The months following Margaret's departure brought other changes to the neighborhood. A young family bought her house and immediately became beloved on the street for their friendliness and their adorable twins. The new HOA board approved a playground near the community center. Property values actually went up, despite Margaret's dire predictions that relaxed enforcement would lead to neighborhood decline. Frank approached me at a community barbecue in late May with a proposition. Kevin, we want to do something about frivolous complaints in the HOA system. Would you be willing to share your experience at our annual meeting? Not in a vindictive way, but as a cautionary tale about how things can go wrong. I considered it. Part of me wanted to move on and forget the whole thing. But another part recognized that sharing the story might help prevent similar situations in other communities or give other homeowners the courage to stand up to HOA overreach. I'll do it, I said. But I want to keep it educational, not personal. Absolutely. That's the goal. I spent a few weeks preparing a presentation about HOA governance, the importance of checks and balances, and what to do if you're facing unfair treatment from your HOA. I included my experience as a case study, but focused on the lessons rather than dwelling on Margaret's behavior. The annual meeting in June had over 100 attendees. When it was my turn to speak, I walked through the timeline of events, the legal principles involved, and the ultimate resolution. I emphasized the importance of documentation, seeking legal advice early, and not being intimidated by official-sounding claims that have no legal basis. The biggest lesson I learned, I concluded, is that HOAs are only as good as the people running them and the oversight mechanisms in place. We all have a responsibility to stay informed and involved. Otherwise, unchecked authority can lead to situations where someone thinks they can claim your property just because they don't like it. The response was overwhelmingly positive. Several people thanked me afterward for speaking up, A few shared their own stories of HOA conflicts, though none quite as bizarre as mine. The board committed to implementing even more transparency measures and regular review of all violation notices. As summer progressed, the shed saga faded into neighborhood lore. Kids in the community started calling it the famous shed, which amused me to no end. I considered putting up a plaque as a joke, but decided that would be taking things too far. In July, I got an unexpected call from a local news reporter who'd heard about the case. "Mr. York, I'm doing a story on HOA overreach in Arizona. Your case came up in my research. Would you be willing to do an interview?" I hesitated. "I don't know. It's been resolved. I'm not looking for attention." "I understand, but cases like yours illustrate a larger problem. HOAs have enormous power, and sometimes that power gets abused. Your willingness to fight back and document everything is exactly the kind of example other homeowners need to see." After discussing it with Thomas, who thought it might actually be helpful for other people dealing with similar issues, I agreed to a brief interview. The story ran in late July, focusing on the broader issue of HOA governance while using my case as one example. The reporter had done her homework, interviewing legal experts about adverse possession law and finding several other Arizona cases of HOA disputes. The article generated some discussion online, with most people expressing disbelief that an HOA president would try such a tactic. A few commenters shared their own nightmare HOA stories. It reinforced my appreciation for how things had turned out in my community. By August, life had fully returned to normal. I barely thought about the shed except when I needed to grab something from it. The restraining order against Margaret was still in effect, but since she'd moved to a different city, it was mostly symbolic. I'd heard through the grapevine that she'd been denied a position on her new HOA board after someone looked up her history. On a particularly hot afternoon in late August, I was replacing some weather stripping on the shed door when a car pulled into my driveway. A man in his 40s got out and approached with a friendly wave. "Kevin York, that's me. I'm Daniel Foster. I live over in Desert Ridge, about 20 miles from here. I read the article about your HOA situation. I'm dealing with something similar, and I was hoping I could ask you some questions." We sat in my air-conditioned living room while Daniel explained his situation. His HOA was trying to fine him for a patio cover that had been approved by the previous board but was now deemed non-compliant by new leadership. "The thing is," he said, "I have all the approval paperwork. But the new president says those approvals aren't valid because they violated the covenants." "That's not how it works," I said. "If you got approval in good faith and built according to those approvals, they can't retroactively revoke it. You should talk to a real estate attorney." I gave him Thomas Richardson's contact information and walked him through the importance of documentation and not backing down when you're in the right. "The key is knowing when to fight and when to compromise," I told him. In my case, there was no compromise possible. Margaret wanted my shed gone, and it was legally permitted and properly placed. Sometimes you have to draw a line. Daniel thanked me profusely and left. I hoped things would work out for him better than they initially had for me, though at least he was being proactive rather than waiting until a lawsuit landed on his doorstep. That evening, I stood in my backyard looking at the shed as the sun set. It was just a building, 12 by 16 feet, painted desert tan, storing yard equipment and tools. But it represented something larger now, a reminder that standing up for yourself matters, that documentation is crucial, and that sometimes the most absurd conflicts can teach the most important lessons. I thought about Margaret occasionally, wondering if she'd learned anything from the experience, or if she'd just moved on to torment new neighbors with her particular brand of HOA zealotry. I hoped for the sake of the people in Sun City that she'd found some other outlet for her need to control things. The shed door needed some WD-40 on the hinges. I made a mental note to take care of it the next day. Regular maintenance had kept it in good shape for 7 years now, and I planned to get at least another decade out of it, maybe more, just to spite the memory of Margaret's attempt to claim it. As fall arrived and the Arizona heat finally began to moderate, I found myself genuinely grateful for how everything had turned out. The legal fees had been repaid, the harassment had stopped, the neighborhood had improved its governance. My property remained my own, with all structures intact and properly permitted. In October, the HOA held elections for board positions. I chose not to run, having served my term and fulfilled my civic duty. The new board members were all reasonable people who understood that the HOA existed to serve the community, not to provide a power trip for petty tyrants. Frank stepped down as president, feeling he'd done what was needed to stabilize things. A retired engineer named Patricia Evans took over, bringing an organized, systematic approach to HOA management that felt refreshing after years of Margaret's chaos. At the November board meeting, Patricia proposed naming the community's annual Good Neighbor Award after Frank, in recognition of his work in reforming the HOA and removing the toxic leadership that had plagued the neighborhood. The proposal passed unanimously. Life continued in its pleasant, uneventful way. I dated someone I met through friends, took a promotion at work, and planned a vacation to Colorado for some hiking. The shed featured in exactly none of these activities except as a place to store camping gear. In December, I received a Christmas card from Jim and his wife. Inside was a gift card to Home Depot with a note. For shed maintenance or whatever you need, thanks for making this neighborhood a better place. It was a small gesture, but it meant something. The whole ordeal had brought out the best in some people and the worst in others. I was glad to be surrounded by more of the former. On New Year's Eve, standing on my patio watching fireworks in the distance, I reflected on the year that had passed. It had started with a delusional HOA president measuring my shed and claiming ownership, and it was ending with peace, order, and a well-functioning community association. The storage shed still stood exactly where it had always been, 15 feet from my property line, properly permitted, HOA approved, and indisputably mine. It would probably outlast me. A simple structure that had become the unlikely protagonist in one of the strangest property disputes in Scottsdale HOA history. I raised my glass to it in a silent toast. To sheds, to standing your ground, to judges who see through nonsense in 10 minutes flat, and to the simple satisfaction of being proven right when someone tries to take what's yours. The fireworks continued to burst overhead, brilliant and temporary against the dark sky. But the shed remained solid and permanent, a testament to the fact that sometimes the good guys win, sometimes justice prevails, and sometimes a storage building is just a storage building, no matter what delusional HOA presidents might claim.